In this video, I am going to tell you about one very important right of citizens. In fact, this right has been settled by a judgment of the Supreme Court. The question is whether a person has a right to marry according to one's choice. Is it a fundamental right to marry according to one's choice? Well, this question has been answered by the Supreme Court in the affirmative in the well-known case of Akila Ashokan versus Safin Jahan. In fact, the name of the case is Safin Jahan versus Akila Ashokan case. And this case is famously known as Hadia case. The judgment of the Supreme Court was pronounced in March 2018. And in this judgment, the Supreme Court, speaking through a majority of 3 judges out of the 5 judges Constitution bench, said that the right to marry according to one's choice is a fundamental right forming part of right to life in Article 21 of the Constitution. In order to appreciate this point, we will have to cast a brief look at the facts of the case. In fact, in this case, what had happened was that a girl named Akila Ashokan from Kerala was in fact studying in a homeopathy college at the Salem district of the neighbor state Tamil Nadu. And at one point of time, an information was provided to her father that she is no more living in the hostel attached to the college, and she is in fact living in the house of one friend who is not of her religion. And it was also reported to her father that she has converted to another religion and she has married to one person from other religion, and that person is residing in a Gulf country. So, feeling aggrieved at it all, her father first approached the local police there in the Salem district of the state of Tamil Nadu, but finding no appropriate response, he ultimately filed a writ petition at the Kerala High Court by way of Article 226 of the Constitution. And the Kerala High Court issued the writ of habeas corpus, whereby it had the girl produced before itself in order to find out the reason for the reason of her absence as such. So when the girl was produced before the Kerala High Court, the judge there inquired as to how come she is not living at the hostel, what are her situations in present. And when she told the court that out of her own volition she had married to one Muslim boy, one Muslim male person, and she has converted to Islam. So the hearing continued in the habeas corpus petition at the Kerala High Court, and finally, in a very peculiar sort of exercise of power, the Kerala High Court said that just because you are a grown-up girl, you are of 25 years of age, you do not have a right as such to marry without reference to the choice of your parents, because you are in a vulnerable age, and the whole circumstances surrounding your conversion to Islam and your later on entering into marriage with the Muslim boy raises a lot of questions, and they need a thorough investigation, because it has been alleged by your father that you are about to be transported to a foreign country for illegal purposes. So in seeing the overall situation, the Kerala High Court ostensibly exercised its jurisdiction as a parent's patriae. That means that being the parent of the unprotected person, this court is of the view that your marriage with Safin Jahan should be annulled forthwith, and you do not have a right to marry in this manner without taking into consideration the wishes of your parents. You cannot perhaps marry. So in an extraordinary exercise of power, the Kerala High Court, exercising its jurisdiction of parens patriae, and in the hearing regarding the habeas corpus petition itself, the Kerala High Court annulled the marriage. Mind you, this was a kind of unprecedented exercise of power by any high court in the history. When the husband of the girl, unfortunate girl, approached the Supreme Court by way of a special leave petition filed under Article 136 of the Constitution, the name of the case became Shafi Jahan versus Ashokan Kem. Ashokan Kem is the name of the father who was arrayed as a respondent at the Supreme Court. And here Justice D.Y. Chandrachud, he was then only a puisne judge. He later on became the Chief Justice. So while hearing this case, Justice D.Y. Chandrachud also issued the writ of habeas corpus, and accordingly the girl was produced at the Supreme Court. And Justice D.Y. Chandrachud and other judges also inquired of her personally about her conversion to a particular religion, about her choice of marriage, etc. And when she affirmed that she is not under any pressure whatsoever, as she converted to Islam or she entered into marital alliance with the Muslim boy. So this way the Supreme Court got convinced that this is not a matter where the girl has converted to a particular religion under pressure. And when a person is willing to do something, how come can a court prevent him from doing that? Justice D.Y. Chandrachud wrote in his elaborate judgment, citing examples from several cases, and most importantly from Article 16 of the Universal Declaration of Human Rights. Mind you, Article 16 of the Universal Declaration of Human Rights, as you are aware, Universal Declaration of Human Rights issued on December 10th, 1948. So in this Universal Declaration of Human Rights, Article 16 says that marriage is a private matter of the intending spouses, and without being fettered by the considerations of religion, race, sex and nationality, willing partners can enter into marriage. Whatever your nationalities may be, whatever your religions may be, whatever your racial identities may be, you can very well enter into marital alliance of your own choice. And it is the duty of the intending partners to enter into marital alliance and set up their own home. Society has no business interfering in their personal right as such. And furthermore, here also in India, according to our culture, the marriage is the choice of the partners itself. Of course, parents do play a role, but in modern times, so far as the demand of liberty is concerned, partners, if they have become adult, if they have become grown up, then certainly they have all the rights to pick up their partner, to choose their partner and enter into marital wedlock. So this way, right to marry according to one's choice was held in this judgment by the Supreme Court to be part of right to life contained in Article 21 of the Constitution. And this is not the first time the Supreme Court has given an interpretative expansion to right to life as contained in Article 21. In fact, this judicial trend, as you are aware, had begun way back in 1978 when in Menka Gandhi case, in Menka Gandhi versus Union of India case, the Supreme Court had said that right to life as given in Article 21 doesn't simply mean animal existence of right, it means more than that. Whatever is necessary for having a civilized human life should be read as forming part of right to life in Article 21. And in that case, Menka Gandhi case, the Supreme Court had said that right to travel abroad is part of right to life given in Article 21. So what? Right to travel abroad is not mentioned in either Article 19 or in any part of the Liberty Clause, but it can be read to be as a part of right to life in Article 21. And in this very case, the idea of due process of law also got enshrined into our constitutional jurisprudence, because in A.K. Gopalan case in 1950, it was the view of the Supreme Court that whatever law is enacted by the legislature if there is a procedure laid in there that deprives any person of his life or personal liberty, then it wouldn't be the duty of the court to adjudge whether that procedure is just or human or not. And this view, quite a literal interpretation was given of the procedure established by law given in Article 21 by the Supreme Court in A.K. Gopalan case. So it was like a very, long journey for the Supreme Court to take. And in Menka Gandhi case 1971, this journey achieved its culmination when the Supreme Court said that the procedure established by law as given in Article 21 doesn't simply mean any procedure of law. A procedure of law depriving any person of his life and personal liberty should be a just and human procedure. And in order for a procedure to become just and human, it is necessary that that procedure must be fulfilling the requirements of natural justice principles. Mind you, in America, Fifth Amendment of the American Constitution says that no person shall be deprived of his life, liberty, and property without due process of law. And in America, due process law has been interpreted to mean the process of law based on the natural justice principles. Now the question arises, what are the elements of the natural justice principles? Primarily, the natural justice principles partakes of three important principles like audi alteram partem, means nobody should be condemned unheard. Before you condemn somebody, before you proceed against somebody, before you punish somebody, the state must give notice to that person so as to enable him to prepare for his defense. And the second thing in natural justice principle is nemo juris in causa sua. Nobody should be a judge in his own cause. Means every procedure must ensure that nobody should become a judge in his own cause, so as to avoid biasness in governmental action. And also the doctrine of fairness is part of natural justice principles. So natural justice principle, in a way due process of law, has now become part and parcel of the Indian constitutional jurisprudence thanks to the decision of the Supreme Court in Menka Gandhi case in 1978. So in our constitution, procedure established by law as given in Article 21 has now become almost equivalent to the American due process of law, which partakes of natural justice principles. Now, this judgment of the Supreme Court was further utilized as a judicial trend in future decisions of the Supreme Court also. And the most recent one was the Hadia case of 2018, in which the Supreme Court said that right to marry according to one's choice is part of right to life in Article 21 of the Constitution. Just 1 year back in 2017, in K. Puttaswamy versus Union of India, the Supreme Court had said that right to privacy is part of right to life in Article 21 of the Constitution. So, because of these decisions of the Supreme Court, the idea of right to life has gained very, illustrious evolution in our country. And because of which, the sanctity to human life has grown up manifold. And this is a good sign that our courts have become anxious. They have been, pronouncing judgments that add value and meaning to the right to life as ever. Thank you.